Call to rise.
Yes, Mr. Rowling.
Lords and my lady, I only have six relatively short points in reply, which I shall now make. The first arises out of my learned friend's propositions by way of testing, as he put it. His first proposition was that all businesses may have commercial goodwill, but you only recognise it in the balance sheet when it is purchased. And my point in reply in relation to that is that when it is recognised in the balance sheet, one is recognising the value that is already there. You're only recognising it because it is established, and there is no conflict. And that ties in with one of the passages in Breyer, to which I referred the court earlier, and I don't propose to go back to, at 45, where it said goodwill is present value. It wasn't necessary to have a sale to produce that value in that context, and I say it's no more necessary in this context either. The second point arises out of his second proposition, which is you may have commercial goodwill, but no accountancy goodwill or enterprise value if the price is less than or equal to the net assets. As a broad proposition, I don't disagree with that, but the context for this case is that there was such additional value, which was being recognised and was recognised by virtue of the SPA, and it has to be looked at in that context. My Lords, my third point, I think, arises out of a point that Lady Justice Carr, in particular, has focused on, this question of overpayment or loss of value.
Yes.
The court was taken to the particulars of claim. I just want to perhaps just take the court to a further passage of the particulars of claim. That's the core bundle, tab 15.
I think, in fact, we haven't looked at them all, have we? I know there have been one or two references, but anyway.
I think the court, I had to open when my learned friend was speaking, had a look at least, I think, 42 and 43.
Yes, sorry, yes. Yeah. Anyway, so, sorry, which tab is the...
15.
Sorry, tab 15, yeah.
235.
Thank you. Yeah.
It is absolutely right to say that my learned friend and his junior put it in 43 as for the or in the alternatively. When the loss is then focused upon, which is in 44, and the premise is the claimants have suffered a loss of at least 76 million or at least 15 million, the key section 44.1, the true value of the shares was at least 15 million less than the price of the shares. Subject to findings at trial, the claimants say to the best of their knowledge and belief the shares were worth at least 30 million less than the price paid for the claims for the shares as warranted. So it was very much focused on a loss of value. And that, in my submission, is how the judge approached it. In her second judgment, in paragraph 71, which I think Lady Justice Carr referred me to, which in the bundle is at 191. The court there, paragraph 71, 191. I am satisfied the fair and reasonable basis for assessing Triumph's loss is the reduction in value of the companies of 5.7 million. So, in my submission, the very... sorry, my Lord, paragraph 71.
Yeah.
So, at the very least, the claim was that there had been an overpayment because there was a reduction in share value. And we say the reduction in share value is because there was less goodwill than thought. So, in my submission, there isn't a proper distinction to be drawn between loss of value in the absolute warranty case and, at least on the facts of this case. And in any event, the wording of the clause is quite wide. It is relates to a matter in respect of. lost goodwill. So in my submission, if the court was with me on the points up to that point, that is sufficiently wide to encompass the claim for loss of value as it's put and as found by the judge, even if reflected most directly by reference to the reduction in price. My lords and my lady, fourth point in relation to clause 13. I made my submissions previously, it was about protecting the value that had been paid. I think the point was being made that it's over a 2-year period, so it's a sort of a continuing thing. In my submission, the value paid could be damaged on purchase by breach of warranty, or indeed it could potentially be damaged by subsequent events over that 2-year period. But whether one's looking at damage at the point of purchase or subsequently, one is still talking about damage to the same thing and protecting the same thing, namely the value paid. My fifth and final point, at least in relation to the pure appeal as opposed to respondent's notice, was my own friend said in his submissions that I hadn't addressed the point that there's any basis for bringing a claim for breach of warranty 19.5 on the basis of my definition. That's not right. In my submissions, I referred specifically to the customer relations, which was referred to in Triumph's TGI's accounts for 2014, which was valued at 3.5 million. That was a precise, capitalised value of existing customer contracts, which is an identifiable intangible asset, as opposed to the unidentifiable asset, which is caught by the description of goodwill. And a claim could be brought in respect of warranty 19.5, for example, if the forecasts had wrongly stated matters in relation to those existing contracts. My final point was in relation to the respondent's notice. I think perhaps at the end, and for the first time, I can take this from my skeleton. There were really 3 short points, which in my submission should be accepted by the court. First of all, if you have the skeleton, it's in the bundle at 47. Firstly, by distinction to at least some of the other clauses which refer to goodwill, it's not limited by where it's recorded. It's put in simply lost goodwill. It isn't, by way of contrast to clause 13, for example, reference back to the target group, or indeed paragraph 3.1 of Schedule 8, which refers to the business or goodwill of either company. So at least on reading it is at large. My second point is it really makes no sense to say it must have been intended to relate to the goodwill recorded on the books of the companies, when the very target accounts which were attached to the SPA recorded 0 for goodwill. Why would you, in the context of this particular agreement, look to exclude something which was impossible to arise? It would make it entirely OTOs, and in my submission that's not what was intended. And my third and final point, and it obviously hangs on having got this far in the argument, there's really no difference in any event. And this is 54. The goodwill shown in the TGI accounts represented what Triumph paid for the companies as they understood, to reflect the value in the entities below it, which it had purchased over and above their net assets. So one comes back to the fact there is really no conflict between the two in any event. We're not talking about separate things. Unless I can assist any further.
No, thank you very much.
Thank you very much indeed, Mr. Morgan. So that concludes the argument, unless there are any further points arising on either side. It just remains to say what a pleasure it's been to conduct a real live hearing after many months of online appeals, and to thank you both very much indeed for your, and those behind you, for your very helpful and clear written and oral submissions. We will reserve our judgments and I'm sure you both know the drill, but in due course you will receive them under embargo in the usual way, asking for errors and obvious mistakes to be corrected, but not for the case to be re-argued, and then we will invite you in the usual way to agree an order if you can. If not, make brief submissions on paper, which we will deal with on paper unless we notify you to the contrary, which is very unlikely. And the hand down will either be virtual or real, depending on circumstances. But I think that's really all I need to say at this stage, other than to repeat my thanks to you and indeed to the shorthand writers who we can't see here, but who are have been providing us with what will be a very helpful transcript of the proceedings. So thank you all very much indeed.